welcome to Perspectives, where we take a deep dive into the issues of the day and where we also take a look at people's opinion on such issues. I am Ruth Osime.
And I am Olatorera Majekodunmi-Oniru. On today's show, we will discuss wills, trusts, and interstate succession.
Welcome back to Perspectives here on Arise News. Dying intestate means dying without writing the will. Simply put, it means dying without leaving clear instructions on how your assets should be dispensed with. The issue has, over time, become a source of friction and sometimes full-blown civil war for many families affected by it. It becomes worse when a family is already deprived of harmony between themselves. So even if your family do know what your wishes are, dying intestate gives them no control over your estate or your legacy. The court does. This lengthier estate administration process can not only delay how soon your loved ones receive assets, they also cost money from your estate that could have gone to them. On paper, the administration process might seem like a completely reasonable answer. First, your assets go directly to your spouse. If you have children, your spouse share the assets within themselves. If you're married and have no children, your property goes to your next closest relative, starting with parents or siblings or more distant relatives such as cousins, uncles, aunties, etc. As we will see, however, this is not a one-size-fits-all solution. Depending on your circumstances, intestate succession has caused many problems between siblings, wives, and children of the deceased. Blood feuds have been known to last for decades with no resolution in sight. Properties have decayed with neglect because disputes have not been resolved. We see them all over the place. Relationships have broken with no signs of reconciliation. Many offsprings of such circumstances have been deprived of the benefit of their inheritance from this act of their father or mother dying intestate. Some executors have also exploited the divide between families and inadvertently benefited financially by channeling the income from these controversial properties to their own pockets instead of the families. They either take advantage of the breakdown of communication between the families or liaise with one member of the family by jointly committing these fraudulent acts, especially with the said member. In most cases, executors usually connive with the first son of the deceased. We've heard it happen many times before. So therefore, creating a will is one of the most critical things you can do for your loved ones. Putting wishes on paper helps your heirs avoid unnecessary hassles, and you gain the peace of mind knowing that your life's worth of possessions will end up in the right hands. That is why it's so important to make a valid will and keep it up to date.
Very well said. What happens to the people, the structures, the organizations, and the causes we worked so hard to build? What happens from the point we retire to the point we become incapacitated and eventually die? What happens in tragic situations of unexpected or sudden death? Will the children we brought into the world and other dependents live wisely, progressively, and happily after we are gone? Will the strength of our impact be felt by unlimited generations to come? There's so much to think about when it comes to estate planning, but the great importance and urgency of establishing and updating wills cannot be underestimated or left till the last day. Through estate planning encompasses a solid legacy, it is the future of everything we work so hard to witness. Securing the future is an important responsibility of every household leader, not just relating to rich and affluent people, but anyone who has valuables, including natural and intangible assets, to pass on for many generations. Lack of thorough estate planning could be disastrous after life, especially with large, blended, complex, or secretive families. Similarly, dying intestate without an estate plan or will can get ugly, with dependents evoking unbelievable family drama and expensive court battles. You've worked so hard to live a successful life and amass wealth in various forms. What happens to your assets after you are gone? Have you established your afterlife wishes? Are your loved ones protected? Will your legacy outlive you? We have two expert guests joining us to dissect today's topic. But for right now, let's watch this special report. Perspectives, we'll be right back.
If there is one thing any family tries to avoid, it will be the battle of who gets what after the death of a parent. The death of a parent is a difficult time, and this tremendous loss can deepen rifts and cause problems among siblings. Money often rears its ugly head as an issue. A last will is a legal document that isn't easily tossed aside. Just because a sibling decides to contest the will doesn't mean they are going to actually overturn the will. Under probate law, wills can only be contested by spouses, children, or people who are mentioned in the will or a previous will. When one of these people notifies the court that they believe there is a problem with the will, a will contest begins. A sibling can't have the will overturned just because he feels left out, it seems unfair, or because the parents verbally said they will do something else in the will. The dirty fights that can ensue when these types of issues arise can lead to many properties going to waste because families are squabbling over them. There is also the concern of executors who exploit the family feud and channel the revenue from properties to their pockets, instead whilst the beneficiaries are too busy fighting themselves to notice. I end by saying, there is a lot to lose when a family decides to fight dirty for properties left behind by a deceased parent. At the end of the day, all parties involved might lose the actual essence of being a family. Ikenna Kingsley, Arise News.
You know, the most amazing thing about this will thing is that you see siblings who used to be very, very close. I mean, as in, they really had a strong relationship. And then the father dies, and all of a sudden, there's this enmity that is so strong. It's almost like a Russia and Ukraine kind of situation. You know, and I can't, because I'm very close to my siblings, and I just can't imagine what it can be that will cause so much divide, but it actually happens.
It happens.
It actually happens. I mean, I know of a famous family, I mean, I'm not going to call names, that I remembered when they were doing the 10th year remembrance of their father or something. We had to cover both events because there were two separate events that were held. And we couldn't cover one person's event and not cover the other person's event. These are people who, they're not different mothers. They're the same father and the same mother. Another thing I also want to wonder, well, I mean, I'm just as guilty, is that I don't know why people find it so difficult to actually write their will. It's not, I know it obviously means, you know, you're accepting that you're not going to live forever. But the truth of the matter is that a lot of people die intestate. Right. They don't leave wills behind, you know, and this has caused so much divide. I mean, like you said, when the guest comes in now, we're going to obviously ask many probing questions because I know of many cases that are in court right now.
I think you sent me one video some months back, the man that was dying in his death.
Oh yes, you saw that video.
And the family members were arguing over
and then
his
the wife
head.
was arguing about how much she had paid, that they should pay her back how much she had. Exactly. Right. And the man wasn't dead. He wasn't dead yet. Imagine what must have been going through his head when all this was happening in front of him.
Just imagine what will happen after he's gone.
Oh my God.
Gets even worse. Like, he's right there, and look at the fracas, look at the drama. When he's gone, what's going to happen?
Yeah, I even talked about that one. There's another one where once a man was alive, he settled his children. He gave everybody their due.
And I like that.
Yes. Okay. But guess what? Now that the man has died and he was now with his second wife, the children have come back now to contest the will.
What happened to his second wife? What did you say?
The second wife, he was with his second wife, right? Obviously, she had her own children. I think also came in with children from her own.
After he had given them.
Yes. Okay. So I think knowing the kind of controversy that was going to ensue, he decided to settle everybody whilst he was still alive, which everyone was okay with. Okay. He now dies. First and foremost, I think he died outside Nigeria. So there was an issue about bringing the body in or not bringing the body in. Why was he allowed to die? Blah blah blah. Because the wife had, you know, her own decisions that she had to make. But now they're contesting with her. I don't even know whether the man's body has been buried yet. But my point is, even when you decide to settle your children, do you understand? Especially when you know you're the kind that has several wives, that the first children can still come and contest.
I see what you're saying.
Yes.
There are many times that the children of the first wife still go and try to take from the children of the second, third.
Exactly.
Right,
Especially if the woman came in with her own children from a previous marriage. So you now have those ones and they're like, look.
You're not entitled.
Exactly. Do you understand? But the man must have decided to leave something for them in his will, and probably wisely decided to settle his first set of children, so that, you know what, whatever I do with the rest of my monies or my estate is now my choice.
And sometimes there are always those assets that are just not within the will. They've just not been given out. Maybe he acquired them the last year of being alive or the last few months.
Yeah.
So they're like, okay, who gets this? And that's where the dispute comes to play.
Yeah, but what about the ones who keep secrets? What about the ones who take secrets to their grave and tell the executors, this and this is going to go to this person, but I do not want my family to know about it, because it happens.
Those are the difficult ones.
Yes, those are the difficult ones. It happens. And then sometimes the family would have probably heard about it and want to put the executor under pressure to reveal this, and the executor would insist that this was what I signed with my client. My client said so and so, especially if it's a very controversial person or a very controversial child or what have you.
Yeah.
There's so many.
The secret cases are the most difficult ones. Those are the ones that end up being family
which
drama.
kids?
Secretive cases.
Yes, or maybe
so like
sometimes,
if maybe the man had a lot of debt, didn't want to disclose that.
Oh, yes.
Or he was hiding his true wealth. He would not give it out. He would not split it before he goes.
Yes.
He won't write a will. So afterwards, everyone is scrambling.
How about going to the bank and the bank is telling you don't have much left because your husband is owing A, B, C, D, E. That has also happened many times, where a lot of men die giving their families false impression about what they truly was.
And their dependents are left scrambling. So you can imagine the fight and
drama. Of course. Then on the other hand, you also know of those who have kept their secrets for so long that the families are not even aware of what they have. Many banks are sitting on people's monies right now as we speak, because the husbands or the fathers did not leave any rule as to how these monies should be disbursed, or the families are not even aware.
I had a case like that. Someone that had a lot of houses abroad, and when he passed on, the person that was managing his estate was like, I don't know who to contact.
What about the one that the mistress knew more about the husband's property than the wife did? And when she went to the wife and said, look, your husband has A, B, C, D, E, there was a debate as to how much she should give the mistress. And the mistress said, if I hadn't told you about it, you wouldn't have known. Exactly. So there's so many questions. Anyway, we're heading for a short break, but stay with us, because when we come back, we will have an opportunity to explore this matter a little further with our esteemed guests. Seyi Akinwunmi, foremost finance, insolvency, debt and business recovery and reconstruction lawyer. Perspective will return in just a moment. Welcome back to Perspectives here on Arise News.
Moving on to our distinguished guest today, Seyi Akinwunmi, a lawyer with over 30 years of experience in family law, divorce, succession, property settlements, estate disputes, child custody, adoption, wills, probate, and intestate matters. He is an insolvency practitioner with specialization in debtor or creditor rights, corporate recovery, sales of delinquent assets, bankruptcy, and turnaround strategies. Welcome to our show.
It's my pleasure to be here.
Indeed, at various times in Seyi Akinwunmi's legal career, he has played key roles in high-profile cases involving negotiations and resolutions of divorce cases, as well as property settlement and estate disputes. And just to throw in this one, he's currently the chairman of Lagos State Football Association. Just so you know, welcome to Perspectives.
It's my pleasure.
You know, Seyi, like Olatorera and I were discussing, there's so much controversy on this bill, even a real or no real issue. But I must admit that a lot of people really die intestate because they don't want. I think maybe they feel some sense of, mortality, and they think that they will live forever or whatever. So what is it? Why is it that people find it so difficult to write a will? And at what age should you really begin to entertain the idea?
First of all, I think that the reason why people are reluctant to write a will is there's this foreboding sense of doom that appears to pervade people's thoughts once it's almost like, look, I'm about to die, so so I think there has to be a lot more education. In my experience, we broach that topic because we have individual high net worth clients in particular, and almost to the last person, the first thing is resistance. But I think that really is the reason. It almost reminds you that you're going to die, even though we all know we're going to die. And I think that in terms of when you should start, it should be once you acquire property. Once you start to acquire property, especially as you get older and have dependents, then you should start to put something down.
What about if you don't have properties, but you have other, just basically, whatever it is that you have, whether it's a lot, whether it's small, whether it's properties, whether it's your car, whether it's whatever, at what age, averagely, really, does it make sense? More sense?
It's not really an issue of age, especially now when we have all these whiz kids at 20-something.
Okay, that's true. That's true.
So I think it's about what your thought is and what happens to me after I leave.
Especially when you start having children,
Yes, I think that's important because as we know, people think it's when you have children. For a man, when you have children outside marriage, or that's when there's problem.
But it is usually a problem.
In my experience, believe it or not, the disputes between siblings of the same parenthood is usually deeper than those where you have children outside of the of matrimony. So I think it's really something people need to consider and understand that it's not a signature, of death toll,
right,
or death warrants. No.
I think it comes to play when you have dependents,
yep,
and you feel like you're reaching that stage whereby you have enough and you want to make sure that it continues past you. It could be businesses that you've built, it could be assets that you've accumulated,
yep,
investments,
yep,
your bank account, and you're like, okay, what happens to all of this? I've worked so hard for this. Who does it go to? How does it succeed me when I'm gone?
The funny thing is, again, in my experience, majority of people don't even write wills because they're thinking, what will happen to this after I've gone? They're more concerned about what will happen to my name.
Really?
So if there's a mess after I've gone, what's happened to my name?
But there usually is a mess.
Yes.
Most times.
So they write wills because I want this to be in order, and after me, let my name remain intact. But the converse is when they don't write the will, they don't do it because they don't want their names. They do it for various other reasons. First of all, is this foreboding viewpoint. The second is people have a lot to hide.
I was just going to ask about that.
Yes, and sometimes they don't even want even the lawyer to know.
To know exactly.
So they just sort of push it back, or they write a will and haven't finished because they're thinking, should I let them know this one?
Yes. Whatever.
And
what's
then
the process for documenting the will legally?
Well, it's pretty straightforward actually. All you need to do is ensure that you have somebody who can take your disposition or write it down. Then you need to have a witness to witness the will. There are a lot of legal complications that you don't need to go in here. But the main thing is you write the will or get someone to write the will for you, to witness it, and then to keep it and read it.
I know there's a difference between the oral and written will, and they say sometimes with the oral it can be something that you're writing on your deathbed or something you're writing when you're actually struck with an illness and your mortality is right
been
ahead
assisted by somebody else.
Yes, so they now said that in such cases, most times you need a doctor to be one of the witnesses to show that you were of sound mind. And
I was just going to say that of sound mind is key. Of sound mind is key. A lot of the time, suddenly the man or woman realizes that, okay, actually I'm dying. And then and at that time wants to write the will. But you're scared that, after that, they'll say, look, and I know of one currently, not an old man, but he passed on. He was ill, he was in hospital, he was in a coma, came out of coma, wrote a will, and there's still contest as to whether it was...
Yeah, but at that point in time, was his mind sound enough?
That's apparently. I mean, I wasn't there, so... But apparently, and the doctors did say...
Okay, the doctors agreed that it was on.
But there's still a dispute. So, sound mind is imperative. And if you're sound mind, I think then you're able to understand that I need to show I'm sound mind. So that would advise that person to get a doctor or to do a test. Yes, a witness, or do a test just before.
Anyway, we're going on the break soon because there are many more pressing questions that we want to ask you. So please don't go away. Stay with us. We'll be right back in a minute. See you soon. Anyway, Seyi, before the break, we were discussing so many issues. I mean, there's so many questions I want to ask, but because of time, let's just work with what we have. Yeah. Like I said to you earlier on, there's a situation where the man was married, left his wife, and now is with another woman. Sometimes they do common law, they do traditional, customary law, native marriages, or they're like common law wives. And common law wives are the ones that you're not married, but you've been living together for 10, 20, 30 odd years or what have you. This man now dies intestate. And then the first family, who have been out of the man's life for like 30, 40 odd years, suddenly come up and want to claim the man's property. So in such situations, what is the best advice that you can give to the second wife or the second partner who is now competing with this family?
Well, I think the first thing, and that's the reason why there is the provision for divorce. Once the fact that you don't live in the same house for 10 years, 20 years doesn't mean that woman is not your wife or that man is not your husband anymore. If you don't divorce, you're still spouse.
You're still married.
So that argument as to we've been away for 25 years really doesn't hold that much water in terms of what we're discussing. But if the man then has lived with somebody else and has had children, you don't forget something. Once you're married under the law, right, and you're not divorced, you can't marry somebody else.
Okay, what about traditional marriage?
You see, traditional marriage is not recognized by the law.
Even if you do traditional marriage, it's not recognized
by the law. Once you marry, once you're married under the Act.
Yeah, you have your marriage certificate.
Yes, under the Act.
Married.
So that person is not really wife in the true sense of the law.
Really?
Yes.
But she's still a dependent. So how do we protect a woman like that?
If he dies intestate, I don't see. There have to be a lot more for her to show.
Like what?
Because as far as I know, once you're married under the Act, she's no different from anybody else.
I agree.
So if then she has had children for him, it's a different issue. Because it's those children that may then stand to benefit from his estates.
So you're saying she wouldn't be entitled to anything legally?
But we recognize traditional marriage in Nigeria.
See, if you
recognize it as...
Not legally.
Not legally.
You have to have your marriage certificate so you can go to... You have to present something in court.
Now, if you didn't have... There are two different scenarios. If you didn't have a marriage under the Act...
So why call it a marriage then if it's not recognized? Why call it a custom?
It's a cultural celebration.
No, that's what I was going to say. Sometimes you don't have a marriage under the Act, and then you marry under customary law. Then customary law can kick in. But if you do have a marriage under the Marriage Act, then you can't have another marriage.
What's the difference between customary law and Marriage Act? Because you said if you marry under customary law, it's legal.
Yes, if you can take benefits under customary law.
Okay, so does that apply when it comes to execution of wills?
Yes, inheritance.
Where does customary law take place?
Exactly.
You have different kinds of inheritance laws, right? Within, you have Igbo, you have Yoruba, you have...
depending on the...
Yes. So, for example, somebody in the village marries...
That's traditional.
Yes, that's customary.
You're saying it's admissible in court?
No, that's really where if you don't have a marriage under the Marriage Act, then the customary law. Because look, in your village, my village, there are marriages. And what they do is traditional marriages. Now, when the man dies,
Which is recognized
when the
as-
man dies, there are rules of inheritance.
Okay.
And the funny thing is, they are less troublesome because there are rules there. This child gets this, or the first child distributes this, and all that.
Okay.
But when you have, and even when there are 2 or 3, it's acceptable. So every child have, Ori Ojori, all those sort of things.
Okay.
But when you have a marriage act, you are precluded from coming under that customary law.
But isn't this a bit of a juxtaposition? Because at the end of the day, how do you separate the two? Because
Yes.
if I marry you now, for instance, under customary law, and God forbid your enemy now dies, I will feel just as much a right to being included in your will as a wife that you probably married 20 years ago.
Yeah.
And
If it's a will, there's no problem. Because I give you...
Okay, intestate. No.
Yeah.
We're talking about intestate
But you see,
now.
you can't, no matter how entitled you are, you can't be entitled outside the law.
But so it's customary law outside the law.
I think I see what he's saying. Marriage Act
Yeah.
is what we
Yeah,
go
it's
by
good.
at
Yeah,
the
and-
Yeah, but you also
that's what we do
acknowledge
at the
customary
courts.
law. It's also acknowledged
Yes,
Yes,
customary
but
when
law.
that
you don't
is
have-
some communities. So the
when you don't
communities
have
that
a
will
marriage
go to
act.
court.
When you don't have a marriage act.
Act, yes. So if you're married under the marriage act, you go to registry and all that.
So if you're married under the marriage act,
Yeah.
if I marry you as what's the word? Traditional marriage, it doesn't hold water.
No, it doesn't.
Really? I didn't know that. I thought to a certain extent. Oh, so if that's the case, we might as well not talk about common law wife, where you've lived with the man for so long, but you never married him.
Yes, so the way around that for the man is to do a will.
You would have thought that anybody that has any controversy or any situation that is not the norm, one would have thought that automatically what you do is
Yes.
write an intestate.
Yes.
Okay, let me even go as far as, what about children born outside wedlock? Because I've heard of situations where a child was born outside wedlock, the father doesn't accept the child, do you understand? But the mother insists that the child belongs to the father.
Yeah.
And wants a DNA test. Okay, let's just assume that, for instance, the man now passes and no DNA test was taken out. Is there any way she can legally insist on DNA test from the remaining siblings to her child to prove his paternity?
Well, I guess proof of paternity is key to show that one is a child of a particular person. But I guess maybe we should tarry a while. I think there's one matter in court now, so let's see what happens at the end of that. Because this DNA issue has not been, it's new in Nigeria. Relative.
But it should not be new.
Yes, but it's still
Because there are a lot of
relative,
children
yes.
walking around who are being denied by their partner. No, seriously,
Yeah.
who are being denied their rightful inheritance or being denied acknowledgement by their parents.
I think
by their father.
it will be determined. Of course, there are various ways to go around it, but it would depend on what the court says.
Also, it's a new angle now. It has
Yes.
never been something that the court has ever taken into consideration.
It may have, but I don't know of any case that has gone the whole hog. I've known of cases where there's been the father, and the child, but I haven't known of any case where the father has passed on and then said, look, the siblings should come and do a DNA test to find out their siblings.
Because you can do that, right? You can do with siblings.
I
to check.
assume that you can. I mean, that's the whole essence of DNA.
There's also the issue of where, like we were saying earlier on, where some people want to take their secrets to their grave.
Oh, yeah.
Maybe this child is something that, or someone that the father has accepted but doesn't want the family to know, or maybe the father has set the father has set something aside for either his family, extended family, whatever. But he has sworn his executor to secrecy. That no matter what happens, this and this and this must go to.
Yeah.
You understand? Now, if by fluke, for some reason or the other, the family find out about that the father had A, B, C, D, E, is there any way they can put enough pressure on the executor to reveal to open the man's secret? Because some secrets, some people want to take it to the grave.
I think that, that's why, the position of an executive is one of trust. And in some cases, you actually appoint a trustee. And the trustee is bound by his instructions. So you can't, if there's a will, for example, and it says, give this to A and this to B, and then there's this C you give to whoever else. Those are your instructions. So A can come and say, I insist that you must tell me
But what if they feel that the person wasn't in a clear state of mind as of when they wrote
So,
that will?
so the first thing is
So that unfavored them.
the first thing to do is to show that to argue that case. That
How do you win such a case? How do you prove that?
sound mind. I mean, there are lots of cases that have accusations or allegations of unsound mind. For example, maybe at the time he was very ill, or she was very ill, or at the time there had been some actions which are not really coherent in line with the way the person acted before. Also, you know,
is that not now hearsay from the accuser to?
No, that's why you need to prove it.
Let me ask this: do most people reveal who their executor is before they pass on?
Yeah, that's true.
Most people don't.
Most people don't.
But a lot of people, but many times they know. But most people don't. There's no reason to this. What people do most times is write the will, and the will is secret anyway.
Right.
Also, why don't they tell their family?
Since
who
the will
the
is so secret,
Yes.
how do the family members, the dependents, actually trust that the executor or the person in charge of the attorney is actually being truthful, honest?
You know, sometimes what happens is that you lodge the will.
You what?
Lodge the will.
Okay.
So you seal the will and lodge it
In a bank.
in usually in courts.
Okay.
Right? And then you unseal in front of everybody and read what's there. So in that case, it's easier to believe. But you see, the thing with wills or even dying intestate is that there's the opportunity, and that's why we have so many of these cases. We have a whole arm of the courts dedicated to family law, right? We have the opportunity to question, but you have to prove, like anything else. You have to prove it. It's not enough to go and say no, is lying. What is the proof?
But let me ask something, because I've also heard stories of where, especially when a man has so many children and there's a first son or something, I've heard instances of where properties have been left to decay because they're in court. Or sometimes one child grabs hold of certain properties and just puts it under his belt and is collecting rent and what have you. And I've also heard of executors that exploit the discord between the families.
Oh yeah.
So a lot of the properties, a lot of the money's revenue coming from the properties will now go into his own pockets rather than that of the family. And sometimes, like I said earlier on in my intro, they usually work in connivance with either the first son or somebody in the family that has, they've settled themselves.
Okay, so we have an experience in that regard.
So what in that case, what do you do?
And what the child did, in fact, the child was the last born. And the child went to court with arguments. And what then said is, look, all these rents pay into the courts, pending the resolution of these matters. And within a year, they resolved the matter.
Really? But can the children decide to change the executor if they don't like?
No, it's not theirs. It's not for them.
Their will.
It's not their will.
No, but are they allowed to? If they find that the executor has
what they can do is go to court and ask the court to sack the executor for good reason.
Okay,
now, the court can then have the state takes over. The state takes over. But you can't say, look, I don't want Ruth.
The state takes over to mediate or to actually take over the assets?
Yes, the assets.
No, not take
to
over.
Distribute.
The inheritance.
So the dependents lose their...
No,
they
to
don't
distribute.
lose.
To
They
distribute.
yes.
To distribute.
And use their own discretion.
Yes. So, but you, of course, again, proof that this person has plundered our assets. And if what the court agrees with, you can't just leave it in abeyance. There must be some appointment of who takes over, and sometimes you have to appoint a receiver over the assets of the estate.
But it's so sad when you see how properties have decayed through years and years and years of neglect.
Yep.
Isn't there a rule or something that can be said that, look, if there's a dispute within so and so amount of time, you must be able to resolve it. Otherwise, the state will decide who goes to what.
Okay, so
rather than just leave it 20,
so
30 years.
if you set up a company and there's a dispute between you and your co-shareholders, can the state say if you can't resolve it, you must go to the state?
No, but I'm thinking the amount of years that goes to waste.
It's the property belonging to this person, and that's the argument for proper advice on preparation of a watertight will. Because if you do the will properly, then it's much more difficult to fault.
Contest.
I agree.
And I remember a few years ago, I was astonished that it's over 10 years until we did the 10-year anniversary. I did the will for a prominent man. And he then said, look, I have children from my ex-wife and also have children from my current wife. And how am I sure that there'll be issue? I said, first of all, when I see the children they don't even care about this property, which is what turned out to be. But we agreed to not only write the will, but also do a video.
Okay.
And now the video in itself was not weighty legally, but it was.
Why is it not weighty legally? When the person is one verbally stating what
I
they
like
want.
the video.
Yes, because see, the thing with video is that you can doctor videos.
Oh,
Okay.
You know, there's so many things that can happen. You can prop the person up. You can, there's so many things. But it evidenced what he wrote, and because what he said, and he wasn't reading, what he said was also what was in the will, and even as we were changing the will over the years, he was endorsing it, so we could show if there's disputes that it was consistent. So there's many things you can do to try and ensure that you make the will provable.
There's an alternative to wills, which is open disclosure while you're alive, or gifting your children what you believe will progress them forward.
That's true.
But there are many people that shy away from that. They're scared of the, toxic nature that can accumulate. A child saying, okay, you give this, you give that this. Oh, this is all you have, daddy. We're expecting way more. What would you say is the ways that we can actually push forward open disclosures? Is it possible? Does it actually happen?
Oh, it does happen. It does happen quite a bit.
Successfully.
And what happens a lot of the time, the ones I have been involved in, have been that the property is in a company's name, and then it's, the shareholding is divided. So, and then the father says, look, or mother says, you can't sell this property. You can only get the benefit out of it unless all of you agree to sell. Sometimes they have more than one property. I went to see a property 2 weekends ago, and the man had built, properties next to one another, and he has three girls, and has decided that, look, each of you take
equally.
Yes. So it depends on circumstances, and I guess you know your children as well, or at least you think you know your children.
Yeah.
Because I find that after people go, people change. So you also need to consider tax issues. There are many commercial perspectives that you need to look at. So the various, it really pretty much boils down to the circumstance of that particular situation and what you think is best. Sometimes you think, as you said, man has a child outside, but even with that woman who had the child for him, they're estranged, and he doesn't want that child to come back. So he says, look, I'll come back, claim anything after he's gone. So he gives everything out while he's alive. So there are very varied scenarios, but I think that it's best to take proper advice from not only a family lawyer in such circumstances, but also a commercial lawyer, so who can marry both.
Okay, what about situations where, because life, as they say, is stranger than fiction. I know of one or two instances where the woman had children for him while they were married. They separated. She left, had a child outside her marriage, but came back in with that child to her marriage. And then now had another child. So you have 1, 2, 3, 4 that belong to the man, and you have 5 that was outside but brought in to the house, and then number 6. As strange as it sounds, it does happen. I'm sure you've heard of something like that. Now, for instance, that kind of situation, the man now dies. And the children now to begin to squabble. Like we said, when it comes to money, you'll be amazed what kind of conflict go on between siblings. And then one of the siblings now says to that number 5 or number 4 or number 3 or whatever number that child is, that after all, you're not my father's biological child.
And wasn't adopted too?
No, wasn't adopted. That's like I said, the woman, when she was separated, estranged from her husband, had this child. The husband now came back and said he wanted her back. So he took her back with her child.
Yep.
Do you understand?
She has a different last name.
No,
That's
no,
her
no.
own father.
She gave the child has
man's
the last name of the husband in the house. So in such situations where this child, sometimes the child might not even know that there was a different father.
Then it's the mother that should play that unifying role.
Now, apart from
between
even
her
the role the
children.
mother plays, when the man now dies, like he rightly said, or that we discussed earlier, you'll be amazed what kind of rivalry now comes between even siblings of the same mother. Now, in such situations, where one of the siblings now says to the person that, look, after all, it's not as if daddy was your real daddy.
And mommy will say no.
Well, they're not even involving mommy now because they are all adults.
See, the
and
thing
daddy has
is,
died. What now happens? in
Facts
that
are
situation?
facts. Facts are facts. You see, the fact that the man had accepted the child into the house with the mother doesn't make that child his biological child, one.
Yeah, but he has left
And-
the child a will,
yeah.
something for the child in his will.
It is,
because
no,
he sees
If it's
the child
in his
as
will,
his.
then the will
if it's in his will, then it stands. Even if it's
Whatever
to his
his
cat,
will says.
as you know,
Okay.
our English people
That's
do.
what I wanted to
You
ask.
know, once it's in the will, I thought you were talking about intestate.
But if he
Once
doesn't have a will,
Okay, but well, yeah, even worse, if he doesn't have a will.
there is a problem.
Why?
Because it's not his child.
Yeah, but he brought the child up and the child was inside his marriage.
but the mother would make sure that child
You see,
is taken care of.
don't forget that the mother has benefits under the intestate law. So the mother gets something,
Yes.
the children get.
Yes.
But he's not
Yeah,
that
but I
child.
thought, because I was asking and somebody said that any child born within your marriage and grows up in your home is your child.
Grows up
As
in
long
your
as-
home? No.
Yes, as long as you're married to the
No,
person.
not to my knowledge.
Oh, yeah.
Are you serious?
That's
That's
my
interesting.
knowledge.
No, I'm not.
That because the child grew up in your home.
home.
Yeah.
No.
No, I'm not talking about child. The child.
If you adopt
for instance,
it- if you adopt a child, it's a
the
different
wife,
matter.
your wife comes back pregnant with this pregnancy of carrying another man's child, but she's still your wife. You didn't divorce her, and then she brings up this child, has give birth to this child, and you bring up the child as your own.
As your own, not your own. So if you want
Are
that,
you
you
saying
write
that
a
if
will.
the guy is intestate, that child can be
It happens a lot.
If it's not his child.
It's not his child.
even
You know-
though he brought up the child as his own.
Yes. So it's
Wow.
not.
But
It's not
his will, if his will
if
states
his will
protect my child.
protect my child,
yes.
then yes.
Wow.
You see, in fact, it's very.
That was very traumatizing for anybody.
Oh,
that- that
and it happens a
circumstance.
lot. Believe me, it happens a
Can you
lot.
give instances?
Like,
I'm not going to call names. I'm not saying call names.
Yes.
Give instances.
Almost similar. Almost. In fact, almost. When you're saying that, I thought. Does she know?
That shows
Yes.
it's not a common
Yes,
cause.
no,
It's not a rare thing.
No, it's not. It's not rare at all. I even know of one where there are only two,
So what happened?
and the girl did not know
Exactly.
What is
that
That the man wasn't her father.
didn't know.
So
Okay.
when did this come out?
Why did it come out? Yeah.
Exactly. Or why?
Because there was the other sibling found out
Yeah,
How did
yes.
he or
by
she find out?
one of the father's
Okay,
brothers or uncles or something like
Who
that.
brought it
It
up
happened.
after the man died?
Yes.
Oh my God. But even at that, she still didn't want her sister to inherit anything.
So when that happened, he was upset with his mom. That why did you tell me? Right, and then that escalated into other things. Ultimately, the child did get him.
That's
They
the
get
thing.
everything
Exactly.
to the first one, to the other child, and he just divided into two.
Oh, who divided it into two?
The child, the recipient.
biological
Oh,
child.
the biological, that's
Yeah.
very good.
Yeah,
Because
so-
you hear of
That's how
instances
things
where,
should be.
yes, that's how it should be. Because
Yeah.
you've known this person all your life. You,
Yeah.
you don't know the person to be
Right.
any different.
Be so
I mean,
fair.
why would you want to now let this?
Yeah. Well, a lot of time, it's pressure from family.
No, but have
It's
there been instances where this same child who was unknowingly born out of wedlock has been ostracized by the rest of the
I'm sure. I
siblings?
don't know of any particular one where.
That would be good.
But I'm sure there are. I'm positive that there are. I haven't had any experience of that one, but I'm sure there are, because you hear of all these things where the arguments that you're my father's child. You hear it so many. I mean, you've heard it so many times. So
Okay, what about instances where one child is the only person benefiting from the estate in connivance with the executor, like we
Yes.
said before? Because I've known of people who are paying rents maybe 1/3 the price of what they should be paying because one sibling or one child, one offspring is benefiting. How can such things be put? How can you stop such? How can the other siblings put a stop to it?
it's legal advice. You need to go to court and put that it stopped to that. First of all, against the executors, saying, look, this
Yeah, but if the executor is in connivance
yes, so
with the person that is doing
And
this.
they've altered the will and stated
Yes.
Yeah, maybe doesn't alter, but just, because
they're
we're
not-
cause
they're not-
fighting,
you see,
might as well benefit.
what's happening is that they're not taking the letters of the will and putting it into action. So one person is actually taking advantage of that. So the others have a right. Well, they have rights. And if they have rights, if they take proper advice, the easiest way is to first put a stop to the income to one person.
Yeah.
Sometimes they have no evidence to prove
I
that
guess that's the interstate,
the executor
whatever. Yes,
and the
yes.
You know, you don't even need to
First
show.
son
You don't even show
connived.
collusion. Once the will is not being proved properly or executed properly, whether it's connivance or not is irrelevant.
Wait, let me ask this. So there's instances whereby the will is just given to a particular person, a particular 2, 3, 4, 5 people, and all the others who are biological children are left by the wayside. And
I think
this
that one is
is
the
stated in the
customary-
will.
that applies in
But the
customary
ones that were
law.
left on the wayside, they said that, oh, it's the first
First
son,
child or
second
first
child that
I've seen that
connived
happen
with the
a few times.
executors to change the will while this man was on his deathbed or something.
It's that allegation. It's
No,
proof.
but isn't that like,
Right, there's no
like
proof
customary
in that
law? You said according to
area.
sometimes Igbo tradition or
Yeah. Yes, if it's customary law, then
or whatever.
I think that the first child takes everything
Yes,
and all
yes,
that.
and that's so
yes.
fair.
Yes, but you know,
That's so sad, though,
But it
because
works for
Bills have been
centuries,
people
I guess.
Yes,
So
but it should really be changed to the modern times. Anyway, thank you so much.
Thank you.
Seyi. This has really been the most riveting morning. And
Yes.
you handled us well. Only you with 2 women.
I'm telling you, it's not
in
easy.
black and red.
but we
Thank you
pray
so
that
much
you
for
know
being with us.
these things go away.
I hope so, and I hope that 1 or 2 people would have listened to you and learned 1 or 2 things.
Yeah.
That was the whole
Absolutely.
essence.
Yeah.
Anyway, thank you so much for being
Thank
with
you.
us.
My pleasure.
And hope to see you again soon.
That's a problem.
When you ask parents about inheritance, they clam up because such discussions not only bring forth the issue of their mortality, they believe inheritance is about money and should not be discussed, and also discussing it is perceived as greedy. But ask them to talk about legacy, and it's as if you've hit some kind of magic button as they open up about leaving behind family values and traditions. But they must also realize that money is just a piece of that. But like it or not, a will and a testament is one of the most important legal documents any parent will ever make. By having one, you can control your legacy, give back to causes you care about, and more importantly, protect your loved ones. And remember, like I always say, life is a learning curve. So that's all we have time for today. You've been watching Perspectives here on Arise News with me, Ruth Osime.
And with me, Olatorera, Majekodunmi-Oniru. There are blank pages for every living will, living trust, last will, and final testament. Are your pages legally blank today? Who will determine the strength of your legacy if your pages remain blank after life? When we cherish our freedom and the great value in every human life, we plan for and simultaneously protect our future generations. Great discussion today. We are grateful to our guests for joining us and to everyone at home for tuning in. Thank you for watching Perspectives. See you next weekend. Goodbye.